Friends, today we are going to discuss about the constitution, the concept of constitution, what is the constitution, why we should have a constitution at all in a society, and what actually are the ingredients of the constitution, what the constitution informs us, and what's the philosophical basis of the constitution. These are some of the aspects that we are going to discuss in this brief lecture. The one thing we should be very clear about is that, as we discussed in the previous lecture, that why politics is so important as a conflict resolution mechanism, and why the society transited from society to the state. So basically we had addressed that the entire society is a place where there are a lot of conflicts on a lot of grounds, and there has to be someone to do some kind of a conflict resolution, and for that some agency was required, which is the government. And then we said that there has to be certain norms and values on the basis of which the conflict has to be resolved. So therein comes the constitution, that any government or a state that is there to resolve conflicts in the society must have a basis for the resolution of conflict, and that resolution of conflict is done by none other than the highest law of the land, which is called the constitution. So basically every society has a constitution, and that constitution is called the supreme law of the land, which forms the basis of conflict resolution in each and every society. Now the question is that if the constitution is the supreme law of the land, then are there other inferior laws which are subordinate to the constitution? The answer is yes, there are subordinate laws, there are inferior laws in congruence with the constitution. And the first is that the laws which are made by the legislative wing of the government. That means every government, as you know, which is an agency for resolution of the conflict, has three components: the legislature, the executive, and the judiciary. And you would be surprised that all these institutions of the government, all these components of the government, in their own way, they make some law. For example, the legislature makes the supreme law as in congruence with in consonance with the provisions of the constitution. So that is the first set of laws just below the constitution. Constitution is the supreme law of the land, which has been made by the forefathers and our the makers of the constitution, which we call constituent assembly. And the constitution that they gave us, they authorized parliament, that parliament can make certain laws which are which have to be in congruence and consonance with the provisions of the constitution. They also created a federal tier at the second level, which we call the states, and there are state assemblies also, which are the state legislatures, and they also make laws for their respective states, and they are also equally important in that particular state. So these two sets of bodies, the parliament for the whole nation and the state assembly for the states, they make the legislative law, that they make the laws which are just below the constitution. But this law is made by the legislature, but this law is a skeleton law, and there are certain loopholes in that which warrant that it has to be supplemented with some flesh and blood, and that part is done by the executive, which makes the second part of law, which we call subordinate legislation. As the name itself is indicative, the laws which are made by the executive, they are called subordinate legislation. That means the second set of law, the subordinated legislation or delegated legislation, which is called, must be subordinate to the main law which has been made by the parliament. That means the parliament has made a set of laws, and just as a matter of complementary to those laws passed by the parliament, the executive has to put up certain laws which we call subordinate legislation or rules and regulation. And to the rules and regulations and the subordinate laws, they also require some support system, which we call rules and bylaws, etc. And therefore these all together collectively, they constitute what we call the law of the land. But the law of the land, constitution is the highest law of the land, and all these the law enacted by the parliament and the state legislatures, then the subordinate legislation by the executive. And not only this, you will be surprised that even judiciary partakes in the process of lawmaking. And as we'll come next, I'll tell you how the judiciary also formulates certain laws by its own judgment. So many judgments of the Supreme Court and the High Court, they also form part of the legal system of the entire country. So constitution at the top, then laws, then subordinate legislation, rules, regulations, and the judicial decisions, they all together constitutes the what we call the constitution or the legal system of the country. Now when a normal common layman looks at the constitution, he is normally drawn by the fact that is constitution a book kind of a thing that we normally see in the hands of someone like Ambedkar, Baba Sahib Ambedkar. He carrying a bulky book called Constitution, or in most of the law books where you go, you find the Constitution of India, very bulky one. Is that the Constitution of India exclusively, or there are certain other things also which collectively constitute the Constitution? Yes, the text of the Constitution, that the book that you see as a Constitution, is certainly the main Constitution. But at the same time, as you all know, the Constitution was made in 1949 and implemented in 1950, 26 January 1950. And since then, from 50 onwards to this, 2023, we find that a very long time has passed, and we have we are almost 73 years old republic, and our constitution is 73 years old. And therefore the society in these 7 decades and so required several changes, modifications, amendments in the constitution. And as the needs arose, the parliament, through the process of amending the constitution, has brought certain changes in the constitution which we call constitutional amendment. So if today in 2023, if you read the constitution made in 1950, then you will probably not understand the true nature of our constitution. And therefore, to understand the true nature of the constitution, you have to read the constitution that is existing today with so many modifications and amendment. Over 100 amendments have been made, and with all those amendments incorporated in the constitution. So amendments to the constitution, they also constitute an integral part of the constitution. They become the text of the constitution, but you can also study them with the original constitution as a supplementary if you get all the amendments which are very easily available. So amendments to the constitution, they become the second component. Then, as we all know, the constitution and all these laws, they often invite litigation, and sometimes the judiciary, whether it is High Court or Supreme Court, they have to interpret the provisions of the Constitution. Sometimes the provisions of the Constitution are so legal, couched in such a juristic jargon, that it's not possible for the common man to understand, and therefore the judicial explanation, judicial clarification of those provisions of the Constitution and the intent of those phrases, it has to be given in their judgments. And therefore all judgments of the Supreme Court and the High Court, they also become explanatory to the spirit of the Constitution, and therefore they also become an integral part of the Constitution. And of course, there are highly juristic commentaries, like commentaries by D.D. Basu and so on and so forth, and several other jurists also. By D.D. Basu I am mentioning because all the students probably know D.D. Basu very well and his commentaries. So you can relate it to that D.D. Basu, and there are several other commentaries also. So all these commentaries, which are highly scholarly, juristic, and legal in their intent and flavor, they also very lucidly explain various provisions of the Constitution. And often the judges of the High Court and the Supreme Court, they quote all those commentaries to substantiate their viewpoint and give their judgment. So the constitutional commentaries by top experts, top legal experts, scholars. They also sometimes become part of the constitution. And finally, that there are certain unwritten parts of the constitution which we call the conventions of the constitution. Howsoever large a constitution you might create, but it is possible that probably you will not be able to write each and everything in the constitution, and therefore there are certain conventions, traditions which form the part of the constitution. And collectively we can say that all these things, the text of the constitution, the amendments of the constitution, the judgments of the High Court and the Supreme Court, juristic commentaries, and of course the unwritten part of the constitution, the conventions of the constitution, they collectively form what we call the constitution. So these are the ingredients of the constitution. Now once we read the constitution, what constitution informs us? Suppose I ask you a simple question, have you read the constitution? You will say, sir, I have read the constitution. And then I will ask you a question, what the constitution tells you. And then you will be probably bewildered what the constitution is and what the constitution tells us. And therefore, you have to be very categorical and clear in your perception that after having read the constitution, these 1, 2, 3, 4, 5, 6 things, what I am informed about, what the constitution tells us. Number one, the constitution tells us at least 6 things, if not more. We will not go into the detail, but 6 things you must remember that the constitution tells you. One is, the constitution tells you about the structure of the state, what kind of a state you are. Are you a democracy? Are you a dictatorship? Are you a representative democracy? Are you a republic? Are you a monarchy? What kind of a state you are? So after having read the constitution, you are able to understand the nature of your state, the structure of your state, that you are able to understand. That is the first information that we get after reading the constitution. The second thing that we are informed about after having read the constitution is that what is the structure of the agent of the government, agency of the state that we call the government. So what is the structure of the government? And this structure of the government, by and large, holistically, tells us that whether the form of the government is parliamentary or presidential, whether the government is unitary or federal or quasi-federal or whatever, which type of parliamentary, presidential or semi-parliamentary, semi-presidential, there can be plethora of combinations, or it is a Swiss model, or what kind of a government we have. So the second thing is that we are able to decipher what kind of structure and what is the nature of the government, what is the form of the government that we have in the constitution. So structure and nature of the government, form of the government, and also structure and nature and form of the state. These are the 2 things that we get to know. Now the third component is that whatever the governmental structure, you must know the exact structure of each and every component of the government, because when you say government, you are inevitably drawn to the legislature, executive and judiciary. So constitution must also tell you the structure of the government. The constitution must tell you the structure of the executive and the judiciary also, both at the union. If you are a federal, then you must know it at the federal level, and also in the Indian context, you should also know the state level structure of the government. So the third thing that we are informed is what is the structure of the 3 organs of the government. And the fourth thing that we are informed is what are the functions and powers of these organs. What is the function of the parliament, and what is the power of the parliament? What is the function of the executive, and what is the function of the judiciary? What are the powers of the executive, and what are the powers of the judiciary? Similarly, what are the structures and powers and functions of the legislature, executive and judiciary at the second level, that means the provincial level, and also now after 73rd and 74th amendment, at the grassroots level, that is the third tier of the government. So at every tier of the government, first tier, second tier, third tier, is union level, state level and local level, we need to know the structure and powers of all the 3 components of the government. That is the fourth thing that we need to know. And finally, fifthly, we also need to know that individuals are the individual important components in every society and state. So the constitution was made to empower the citizens also. So what kind of power and what kind of rights and duties, liberties they have been bestowed on the individuals and the citizens. Indian constitution make a distinctions between the citizen and the individual. Therefore, I am using both the phrases. But of course, other constitutions probably also would make a distinction. But in the Indian context, there are certain powers and liberties and rights given to the citizens, and there are also certain powers which are given to non-citizen individuals who are living in India. So all these things, rights and liberties of the individuals and the citizens, they form the fifth component of your information when you say I have read the constitution. And finally, that government and the individuals, they both have powers given by the constitution, but can they exercise those powers in a whimsical manner? Can they exercise those powers in an arbitrary manner? No, because the constitution puts certain restrictions. The basic fundamental of the constitution is that it restricts the government also, and it restricts the individual and the citizens also, and therefore both of them, they have to understand that whatever powers they have been given, whatever rights they have been given, it's not just arbitrary. There are certain restraints, and the constitution prescribes certain principles and restraints which govern, which restrict the exercise of powers both by the state and the government on the one hand, and the individuals and the citizens on the other hand. And finally, that what will happen if the society is not has a constitution? Why we have a constitution at all? Can we explain it philosophically? Yes, we can explain it philosophically, because in every society, the fundamental ethical question is the individual versus the state or government. Authority and power on the one hand, and liberty and rights of the individuals and the group on the other hand. And therefore, the constitution is philosophically trying to establish a balance between the individual and the state. It is trying to establish a philosophical balance between the liberty and the authority. So this is the ethical component. This is a philosophical component of the constitution, that why every constitution must differ from any other constitution, because every society has a right and freedom to decide this balancing of the authority and the liberty of the state and the individual. So friends, having discussed the kind of the constitution, we again revert back to this thing, that constitution is finally supreme law of the land, and it is philosophically an effort to show that how the state has been balanced vis-a-vis the individual, how the power and the authority of the state has been balanced vis-a-vis the rights and liberties of the individual. And for that, we have discussed that there are certain instruments and components in the constitution, like the text of the constitution, like the laws of the made by the parliament, like the delegated legislation made by the executive, like the judgments and several things incorporated in the judicial decision. They all collectively constitute the constitution, and there are certain, of course, unwritten practices. They also collectively form the essence of constitution. And therefore, what I think that I have briefly tried to discuss about the constitution, but still, if you have any questions and queries regarding the constitution, you are very welcome to put your questions in the comment box, and I will try to answer all those questions. Thank you very much.